case to come before the court today is State versus Soto, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. So I'll go ahead and keep the clock and just let me know what you want to do. Oh yeah, that's right, I keep forgetting this.
Sorry, you're on guy. Wrong side.
This is a little unusual.
Yes, very much so.
You're fine.
May it please the court, my name is Natasha Guerreri, and I represent the appellant in the state of Ohio on this matter, and would reserve 2 minutes for rebuttal.
Thank you.
Vittorio Soto was indicted on 2 counts of rape. Mr. Soto did file a motion to suppress his confession, alleging that he was in custody at the time of the confession and therefore was required to be provided his Miranda rights warning. The state presented the investigating officer, Detective Tabitha Angelo, as well as the videotape of the interview to the court during the suppression hearing. Detective Angelo testified that she arranged with Mr. Soto to come in voluntarily for an interview. Once Mr. Soto arrived, she walked him back to a conference room where the interview was to take place. While she was walking him back to the conference room, she did let him know that he was not under arrest at that point. However, that was not a part of the video.
That's what I was just going to say. That was what she told him before the video started.
Correct.
Is there anything on the record where she memorializes that, says, now as I previously told you, you're not under arrest or anything? Is that part of the record?
In the actual interview itself, at some point in time, she did indicate to him, you know, you're not under arrest, and he, at that point, immediately responded that he knew he was not under arrest.
But that was after he'd already made the statement.
Exactly, that was after he made the statements. But that it was never prior to the actual interview commencing. It was just on the way back from the conference area. And Mr. Soto did, in fact, confess during the interview that he had sexual intercourse with his 10-year-old cousin when he was 15 years old on 2 occasions. And it was at that point when he asked, should he have a lawyer, and that other conversation transpired where she stated, you're not under arrest, and he acknowledged that he was not. Ultimately, at the end of the interview, he was allowed to leave. He was not placed under arrest. The state would submit that the trial court did err in granting the motion to suppress on 3 separate issues. The first being issues with the findings of fact. Second being some incorrect application of the law. And third, that the trial court erred in the ultimate issue of finding that Mr. Soto was in custody at the time of his confession. With regard to the first assignment of error, a trial court's finding of fact should be granted deference if it is supported by competent, credible evidence. In a review of this type of challenge, an appellate court must determine whether or not the trial court's findings of fact are supported by the manifest weight of the evidence. Here, the state has issue with one of the findings of fact in that the trial court found that Detective Angelo was actually in a police uniform at the time of the interview. Detective Angelo did in fact testify that she was not in uniform, and actually a review of the video indicates that she was wearing khaki pants as well as what appeared to be a polo, although it did have an insignia of the Lorain Police Department on it.
That insignia, part of that is a badge, isn't it?
Correct, Your Honor.
And she had her weapon?
She did state that she had her weapon and her badge at the time of the interview, yes, Your Honor.
Is that standard detective uniform?
She didn't say it was standard detective uniform. She just stated that she was not in a police uniform at the time of the interview. The state would also submit there were several findings of fact that the trial court should have made based upon the record that are important in determining whether or not the defendant is in custody for purposes of Miranda. The first of which I previously touched on, in that Detective Angelo did indicate to Mr. Soto that he was not under arrest, and again, not on the tape, but his statements later in response to Detective Angelo reiterating that he was not under arrest did show that he acknowledged and knew that he was not under arrest at the time of the interview.
What does under arrest mean to a lay person?
I'm sorry?
What does under, when you say under arrest, when you're talking to a lay person, when you say, yeah, you're not under arrest, And he says, oh, I know I'm not under arrest, after he's already said everything. And then, what does that mean? What evidence was there, you know, in regard to him actually knowing he was not under arrest for the legal sense? Because not in the sense of what lay people think of being in handcuffs and not and being booked.
I guess some of those other factors that I'm going to go through here kind of lend toward that. That he was never actually placed in handcuffs. That's something that lay people automatically connect with arrest, and at no point in time was he ever placed in handcuffs. He actually came down to the police station voluntarily. That was made through phone conversation between him and Detective Angelo, and she did thank him for coming in and did mention that he did come in voluntarily during the actual interview itself. I guess those two definitely.
Yeah, I guess I was looking at, whenever you said he acknowledged he was not under arrest, I was looking at what else indicia, not that necessarily his subjective belief, because it's a reasonable person standard, as you argued anyway, but I guess I was looking at what other indicia that he might have exhibited to the officer to demonstrate. I understand what you're arguing. I'm saying, because I think you're making a point that he said, well, I know I'm not under arrest.
Well, I know that actually prior to the interview, he was escorted into the conference room. Detective Angelo left her file on the table and then left, and then he started leafing through the file. I think that's probably one indication on that point. Also, toward the end of the interview, Detective Angelo actually left again, leaving him in the room, and he had a cell phone with him as well that he pulled out and started looking at, which is something else. You know, obviously, if you're being placed under arrest, they're going to be taking those type of items away from you, but he was actually allowed to, he did keep that and had that with him throughout the entire interview. And some other factors, just regard to case law, that were present here as well were that Mr. Soto was actually seated closest to the door. There was nothing obstructing his path to the door. Detective Angelo sat across from him, in no way obstructing that path. Again, he was left in the conference room a few times, and during those times the doors were left open, so he was obviously at that point not enclosed in that space. He never indicated at all that he wanted to stop talking to Detective Angelo or that he wanted to terminate the interview. And actually at one point in time, Detective Angelo said, hey, you actually don't need to talk to me anymore. And it sounded like he responded to say, but I don't want to stop talking at that point.
Well, at one point he did ask for an attorney, correct?
He said, should I have an attorney, after he made his confession. And that was at that point that a whole conversation about not being under arrest and all of that took place.
Counsel, I think Judge Callahan.
I'm sorry.
Just prior to that question, when you said that the detective said you don't have to talk to me, is that conversation part of the recorded conversation?
It's on the video.
Okay.
Yes, it's on the video. You do have to listen to it a few times. It took me a few times to actually sit and listen to it, and that was my understanding of what he said after listening to it a few times.
What about the definitive representations that the officer made to him about that he wouldn't be charged as an adult, he would get probation, he would be handled through juvenile court, all those type of things?
And all of those that conversation did in fact take place after the confession. It was actually raised as a separate motion to suppress by Mr. Soto, and the trial court did find that those were not inducements to his confession because it actually took place, that whole conversation took place after the confession.
Was that, I can't remember though, was that on the video too? Or?
That was also on the video, I do
Okay,
believe,
that's
toward the
what
end of it.
I couldn't remember, thank you.
Certainly, Your Honor. And just moving on to the second assignment of error, the state would submit that the trial court actually added in a subjective element to the Miranda test or the custody test, and the state would submit that is in error, that the Miranda test is actually an objective test, a reasonable person test, because in the actual entry itself, the trial court said that what the defendant was thinking is an important consideration when making this determination, and this court actually in sublet did state that the subjective intent of the officer as well as the subjective belief of the defendant are relevant to this type of analysis. So the state would submit that application of the subjective portion of what the trial court added was an error. And then just brief, and then moving on to the third assignment of error, the ultimate issue, that there would be, the legal analysis should be reviewed de novo. And obviously the Fifth Amendment is the important factor here, and Miranda being the seminal case in that area, that if the police take a person into custody, start asking him questions, and do not provide him with his rights, that those statements cannot be used against him. However, the duty to provide Miranda warnings are only involved when custody and interrogation coincide. And the just having a person coming into the police station for an interview in and of itself does not automatically trigger having to provide Miranda warnings.
Even if that person's a suspect?
Even if that person is a suspect owner, yes. Each case should be reviewed upon the fact and circumstance of that case, and the ultimate inquiry is whether, under the totality of the circumstances, a reasonable person would believe that he was not free to leave. And again, subjective, there's no subjective portion to that test. It's a reasonable person objective in those particular circumstances.
Which the trial court did talk about the reasonable person test.
The trial court did in fact talk about it, but then, toward the end of his opinion, then kind of threw in that subjective portion of the test and found that to be an important consideration, which the state would submit as clearly erroneous in reviewing the case law. And the state did place in several cases into the brief with regard to custodial interviews, and I won't go into each one, but will highlight the facts of this case that it believes points to those particular facts of those cases. And the state would submit that, in fact, based upon the totality of the circumstances, that Mr. Soto was not, in fact, in custody at the time of confession, and therefore Detective Angelo was not required to provide him with his Miranda rights warning. Excuse me. The first of which is, like defendants in Amore, Carter, Curtis, and Guzzi, and Luke, that Mr. Soto actually did come into the police station voluntarily, and that was heard throughout the conversation in the actual interview itself, where Detective Angelo thanked him for coming in and did highlight that he came in voluntarily. And another thing is that the interview actually took place in a larger conference room with seating for at least 9 people. It wasn't a small room at all. And again, the state would argue that Detective Angelo was not in a police uniform, although she did have her badge and her service revolver with her. And again, Mr. Soto was seated closest to the door, nothing obstructing his way to leave.
And you are at 2 minutes.
Okay.
The state, if you want.
Okay. Thank you, Your Honor. The state would request that this court reverse the finding of the trial court and remand for further proceedings, and I will reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning.
Good morning.
Attorney Matthew Bobrowski, I'm here on behalf of Mr. Soto. And on behalf, I will work with Attorney Michael Duff. I'd like to address the assignments of error kind of in order. The first issue is the findings of fact, obviously. And I think the most salient one is perhaps Detective Angelo's uniform. Obviously, she was not in her formal uniform. She was not even in her patrolman's uniform, which would not be consistent with her position as a police detective. However, she is a police detective, and they typically are in a more plainclothes capacity in their day-to-day work. She obviously was wearing a polo with the Lorain police insignia conspicuously displayed. Her service revolver was visible, her badge was visible. And I think that speaks to how a layperson, Mr. Soto, would perceive her. You know, he's not perceiving her as in a casual setting. Yes, she was wearing khakis, but she was clearly a police officer in that capacity, and she admits she was in her detective outfit at the suppression hearing. She says
This is the type of outfit the sheriff's personnel would wear out in the community to events,
yes,
for instance, to identify themselves as law enforcement.
It clearly denotes her as a police officer. I mean, obviously, I'm sure, you know, friends and family may get the polo as well, but they obviously don't get the badge and the gun. And in that circumstance where Mr. Soto is in that interview room or conference room as it was, you know, with someone in that type of outfit, it clearly puts a perception in a layperson's mind. Any reasonable layperson would know that they're there with an officer in an official capacity. This was not just a casual interview where they could feel, you know, that relative freedom of not having the status of the police officer be so front and center. Obviously, the other issues that the state brought up in their brief, there's many facts that the trial court did not find, and they were, you could argue, they were there, but they're not necessarily relevant completely to the ultimate issue which he found, and they are present in the record, obviously.
How is the statement, according to the detective's testimony, that when first greeting your client, she said, "You're not under arrest"? There is no comment about that statement in the trial court's order, is there?
No, there is not. And she does talk about it at the suppression hearing, obviously. And she admits that it was recorded only in her police report, which was done roughly about a week later, I believe she said. Obviously, there's no record of it. And though there is some tacit acknowledgement of some of the comments during the interview, I don't believe that there's any explicit acknowledgement of the entire content of what she said occurred in the home. To that end, I mean, obviously, we have, you know, this part of the record, these other facts, in the sense that they were brought up in the suppression hearing. And it does not, Mr. Soto's point of view, it doesn't rise to the level where remand is necessary simply for these omissions, potential omissions in the findings of fact. Then going on to the second assignment of error, which was the trial court's journal entry, obviously the trial court somewhat maladroitly put in the subjective language. They put that in at the end, it's right there, but I think if you look at the totality of the journal entry, it may not be quite as damaging as it looks on its face. On page 5 of his journal entry, the trial court does correctly state the applicable standard. It's very clear that he understands that it is an objective standard and that the subjective element is not part of it. Even at the end, where he does put the subjective element in, it is essentially between two lists of the objective elements for the reasonable person that, you know, talk about that. I freely admit that, yes, that language is problematic. It does not, does not comport with the standard of law. But when you look at the totality of what the judge wrote and how he conducted the suppression hearing itself, where he repeatedly stated that he was applying an objective standard. Obviously,
excuse me, counsel, didn't at one point when I believe there was conversation about the standard between trial court and prosecutor about the objective standard, didn't the judge say, yes, I know I'm to be objective? I mean, that's not the standard we're talking about here, is it?
Yes.
We want to hope our judges are going to be objective.
And he does say it, and I actually quoted in my brief, he says, which is why I'm able to make a decision objectively looking at the facts as a reasonable person would believe that they got it. That's what he says. He says that in the suppression hearing. Obviously, it's the Ohio Supreme Court has stated repeatedly that a trial court speaks through its journal entries. What said in the suppression hearing is said in the suppression hearing, but that does not change what was said in the journal entry. However, when taken in its totality, I believe it's clear that while there was a maladroit use, let's say, of that choice of phrase, the totality is that he did apply the objective standard, which then would take us to the ultimate issue in the third assignment of error. And I think the factors were clear. You know, when you look at Mr. Soto, who's a lay person, and he goes to, obviously does go there voluntarily to the police station. He's escorted back, the door's not locked. I don't understand all these things. But how the interview was conducted with let's say, the Detective Angelo in her detective outfit, the fact that it was clearly meant to elicit a confession, and that he, during the course of the interview, once he realized that he had confessed, there was that moment of concern where he did ask, do I need a lawyer? And we freely admit that once Detective Angelo said, you know, you really don't, you know, he basically, he agreed. He agreed that he was not under arrest. But there was that moment of doubt, and that can be considered, that what a reasonable person would expect one day, based on what they said in an interrogation, can be considered based on in the analysis. And at that point, Mr. Soto had to realize that he had just confessed to a crime. And you know, the remainder of the interview where they discussed the possibility of juvenile prosecution and probation shows his understanding that he knew that something was going to come out of this. That he as a reasonable person understood that the implications of what he had just said and done. And
I'm not sure I understand.
That was a little bit.
No, it's okay. I just don't know that I understand that, because obviously each individual is going to be different in regard to what transpires in the interrogation or in the interview room, whatever you're going to call it. And so that to me goes to the subjective element and not so much the objective element.
Yeah, and I think this, based on the case law, this is something that I've seen in very
Loose.
Mm-hmm. I have not seen a lot of courts applied exactly the same way, but it seems to be that there's almost like a tipping point where if they do something that that a reasonable person should know, puts them in serious criminal jeopardy, that can be a factor. It's not a test that I've seen applied uniformly, and there seems to be a lot of gray.
It seems to me that, and the courts are loath to do this, and I'm not sure exactly why, but that absent, I think most attorneys are arguing anyway that it should be, you're advised the moment you walk in, you know you're not under arrest.
Yes.
And then it's very clear, you have the right to leave. It's almost like a pre-Miranda warning.
Yes.
Well, the state would argue that he was, it just wasn't recorded.
Well, regardless, the point is, the case law, what I'm getting at is, the case law, even not having that, doesn't require that, right?
No, it does not.
No, they don't. The case law doesn't require that. And I guess where I have a hard time with these cases, and you know, the cases over the past decades have basically said almost anything is non-custody for Miranda purposes. You know, until you're actually handcuffing them almost to the table.
Yes, and to that point, Detective Angelo herself expressed some confusion on that point during the suppression hearing, because she explicitly equated custody with cuffs several times, and Attorney Duff made that point that she herself only looked upon custody as where Mr. Soto or any defendant would be sitting there sitting in an interview in handcuffs. And while the case law does cut towards almost to that point, it doesn't explicitly say that custody equals cuffs. And that, I think, does inform how and why Detective Angelo conducted the interview in the way she did.
But Detective Angelo's subjective belief isn't for our consideration either, is it?
It is not, and that was, well, the point I was going to make.
Okay, sorry.
I was going to that point again, and again, it cuts to the subjective statement. But in the end, Mr. Soto, we believe that the trial court ruled correctly that based on the circumstances, a reasonable person would not have felt free to leave, even though, in point of fact, he was. But it is in that moment, he did not feel free to leave, and as such, the trial court ruled correct.
The court in its order says there was nothing to indicate that the defendant was told that he was not under arrest, which seems to be in conflict with the testimony of the detective at the hearing. What do you make of that statement in the order?
That statement is a little bit hard to parse. My interpretation was that the trial court is talking about the interrogation itself, and parsing the interrogation from the walk down the hall, which is unrecorded. That's my only way that I can understand what that is, based on the fact that Detective Angelo did state that she talked to him in the hall and stated that he was not under arrest.
Thank you.
Thank you.
Let's start with that. What do you do about that? Do you just presume that the trial court, by making that statement, didn't believe the officer, didn't feel that the officer was credible?
I don't know if I would take it that far, because the court, it does seem that the court was basically relying on the video to determine what exactly transpired. That seemed to be his sole focus in his decision.
So you would agree with counsel's interpretation of that?
That he seemed to have, yes, that he seemed to have been focusing on what was actually contained within the video and not took place prior to or after it. Although, again, the state would argue that, statements that Mr. Soto made in the video obviously indicates, to the state anyway, that he was in fact informed of that information as he was being brought back to the conference room. And again, it is a totality of the circumstances test, viewed from a reasonable person. And all of those factors that I put in with the brief, pulled from the video itself, all weigh into the determination of custody. And the state believes that all those factors were taken as a whole to indicate, in fact, that Mr. Soto was not in custody at the time of his confession. And therefore, the trial court erred in finding that he was in fact in custody and that he granted his motion to suppress. Therefore, the state would, again, request that this court reverse the finding of the trial court and remand the matter for further proceedings. Thank you.
Thank you. The court will take the matter under advisement, and we will issue a written opinion that will be sent to both sides, as well as we will post it on the court's website. Thank you very much for your arguments and your presentation to the court.